I'm Tavis Smiley, and I'm delighted to have you tuned into our program today, Monday, February the 12th. What a great first hour, and I'm looking forward to this dialogue with Matthew Berry Johnson in this hour. Matthew Berry Johnson is a John Jay College psychology professor whose work focuses on wrongful conviction, more specifically, how psychology informs due process in America. Professor Johnson, whose research again focuses on the areas of interrogation, confession, and wrongful conviction, has discovered that suspects may understand their Miranda rights, but also doubt that police will actually honor those rights when asserted. I am honored to welcome Professor Johnson to this program. How are you today, sir?
Good afternoon, Tavis.
How are you today?
I think I'm fine. And I'm very happy to be on. Are we clear? Because I'm having a little interference on my end.
I can hear you well. Can you hear me okay?
Okay. Well, then let's proceed. Thank you again for your introduction, and thank you for having me on your show. I'm very, very pleased to be on, and I, recognize the importance of your work. We need independent Black journalists, and that's what you've been for several decades. So I'm very happy.
No, you are kind to say that. I'm delighted to have you on. Let me when we push forward in a couple of minutes, we'll get Miles, our board operator, to fix whatever problem you may be having. If you can't hear me at any point, you let me know, because it ain't gonna work if you can't hear me. So if that problem doesn't clear up and you can't hear me, you let me know, and when we step aside for
I'm periodically. Seems like I'm losing you for a few moments, and it comes back.
Okay, we'll work on that here in just a second. Let me see if I can get this first question out, and we'll get that fixed when we step aside for a moment before we come forward and continue our conversation. Let me just ask for starters, how you came to focus on this work about wrongful conviction. I'm always curious about the backstory. How did this become the lane that you run in, working on the notion of wrongful conviction in this country?
Travis, I'm a psychologist by training, and earlier in my career, I was concerned with interrogation and confession. I think you mentioned that in the introduction, and I was fascinated in terms of trying to understand how was it that police could get innocent people to make admissions to offenses they had not committed. And my work earlier, like in the early 2000s, was focused in that area. And I was trying to research, and also I worked as an expert witness with lawyers who were defending people. And then later on, I became aware of the fact that there were actually more people wrongfully convicted as a result of mistaken eyewitness identification, and that this was actually a larger contributor to wrongful conviction in the United States than false confessions. So I began to expand my focus at that time, and I also observed that a large proportion of these cases involved people that were charged with rape and other sexual assaults. And then from there, I just really delved into this.
There's a lot to unpack in this hour, and I'm glad I've got you for the hour. Tell me more about what it is about this interrogation process that does somehow convince or intimidate innocent people to confess to things that they did not do. What is that about?
Yeah, I'm sorry, I didn't get the latter part of the question, Tavis.
What? Let me just do this. I'm gonna push ahead and go to a break here and let Miles get this figured out, because this is problematic. If he can't hear me, then what is the point? Our guest is Matthew Berry Johnson. He is a professor of psychology at John Jay College. He is one of the leading experts in the nation when it comes to the issue of wrongful conviction. As I said earlier, his research focuses on the areas of interrogation, confession, and wrongful conviction. The question that I want to put to him once we get this phone line straight is what it is about this interrogation process. Is it intimidation? I'm curious to learn more about how it is that this system convinces people or forces people or frightens people to confess to things, to admit to doing things that they did not do. Think about, for example, the Central Park Five. They beat those confessions essentially out of those brothers, and we found out later on it just wasn't true. Thankfully, as you well know, one of those Central Park Five members is now a member of the city council, an elected member of the city council in the city of New York. So talk about turning a story around. It's an amazing story, and I'm glad that brother got elected to the city council there in New York City. But his life had been ruined years ago. Because he and these others ended up confessing to stuff that they just did not do. What is that about? A great deal more to talk about once we get this phone line straightened out with our guest, Matthew Barry Johnson on Tavis Smiley.
You're listening to Tavis Smiley.
Tavis Smiley and Matthew Barry Johnson, psychology professor at John Jay College, whose focus is in the area of wrongful conviction. And delighted to have him on this program. So the question that I posed moments ago that you could not hear, that I hope you can hear now more clearly, is what is it about our system that somehow convinces people, coerces people, frightens people, intimidates people, you tell me, into confessing to things that they did not do? I mentioned the Central Park Five as one example. There are many more that I could call upon. This is your area of expertise, so you know this better than I do, obviously. But what is that that somehow again convinces or coerces people to confess to stuff that they didn't do, Professor Johnson?
Well, let me say this. First of all, that is a matter of design. When I say design, the training that police receive in criminal interrogation is designed to make the suspect feel as though he or she is hopeless, that they're desperate, that there's no way that they can establish their innocence, and that they are going to be subject to severe penalties. That is the first step in criminal interrogation. And then once they have the suspect feeling very vulnerable, then the second step is to suggest to the suspect that by making an admission to some aspect or some minimized version of the offense, that the interrogator can actually help them out of their desperate situation. So that what you described is actually part of the design of criminal interrogation.
I'm not naive in asking this, but why is the first attempt to make them feel vulnerable rather than to be in search of the truth, what actually happened or didn't happen?
Well, let me say this. When police interrogate suspects, when they initiate an interrogation, it's because they believe that the suspect is guilty in some way, or is involved in offense in some way, or has some information that they want from him or her. So prior to interrogating them, the interrogators are supposed to do investigation and have some information, have some basis for deciding that they're going to conduct a custodial accusatory interrogation. Sometimes that information is merely a hunch, or it's merely incorrect information they were given by someone who came forward. But once they initiate interrogation, it's their belief that the person they're interrogating is in fact guilty or responsible for the offense. That's a guiding assumption.
Mm-hmm. You're the psychology professor and not me. So while I understand what you just laid out about the intent and the effort on the part of the police to make the suspect feel vulnerable, then get you to believe that if you confess to this, that, or the other, they can help you. I get that narrative. But again, back to your psychology degree, what is it about us? What is it about the suspect that somehow convinces us or allows us to acquiesce to that pressure to find ourselves in a frame that we are somehow convinced to confess to something that we didn't do? So help me understand that part of our psychology.
Well, let me say a couple of things. Obviously, everybody that's interrogated doesn't confess,
right?
And some people that are more capable of resisting the interrogation than other people are. Some people are more aware of the fact that some of the things that law enforcement are telling them may be inaccurate, may be deceptive. So you have those factors. But also the other factors is that, sometimes people are held for 3, 4, 5, 8, 9, 10, 12 hours of interrogation, and they become exhausted. Not only are they exhausted cognitively and emotionally, but during this lengthy interrogation, the police are demonstrating to the suspect that they have no control, that the police are in entire control, and the police will even indicate subtly or overtly that they have other evidence and that they're going to be able to convict the person anyway. So, certainly many people fall victim to this. I'm not saying that everybody would, but I think it's hard to judge people who do falsely confess, not knowing the ordeal that they endured.
Mm-hmm. You mentioned 2 points earlier that I want to interrogate right quick. One is this notion of false confession, which we're talking about now, obviously, and how rampant that is. And the second point you made is wrongful ID, that people oftentimes, especially in these sexual assault cases, your book is called Wrongful Conviction in Sexual Assault. Oftentimes in these cases, people are just misidentified. When it comes to false confession and wrongful identification, tell me how rampant, how prevalent those two factors are in our system.
Well, those are the two leading contributors, or maybe two of the three leading contributors to wrongful conviction. Mm-hmm. So, in terms of my work, what I did was that I looked at the people who had been exonerated, who were data is provided about these cases from the Innocence Project, and then more recently from the National Registry of Exonerations. And what we find is that a large proportion of the people who have been exonerated from criminal convictions were originally charged with sexual assault and rape. In fact, on the Innocence Project website, it's over 70% of the cases that they've exonerated were sexual assault and rape cases. Now, sexual assault and rape cases are not the most common types of crime. Mm-hmm. In fact, they're only, maybe about 10 or 12% of people that are convicted of crime are convicted of sexual assaults and rapes. But then they're representing upwards of 70% of the people who've been exonerated.
I want to ask this question, but I want to be delicate in how I ask it. Let me just do the best I can. How is it that when you are being sexually assaulted, when you're being raped, that you falsely identify the culprit? And again, I want to be sensitive here because I recognize that I can't imagine what it would feel like, and I hope I never have to find out for myself or for anybody I love what it feels like to be sexually assaulted or raped. I'm very sensitive about that. But it seems to me that in that situation, you're face to face, it's one-on-one. You're in this moment. And I understand you may be blanking out. You're not paying attention. I can understand the frame that we're in. I'm only asking what I'm trying to ask, and not doing such a good job of it. Again, I want to be sensitive here. I'm trying to understand why, in sexual assault cases, is there such a high level of wrongful and false ID? You're in a situation where you're in close contact, and yet in those cases we see a high incidence of false ID. What am I missing about why in those cases so many people are wrongfully identified?
Well, you're asking an excellent question, Tavis, and it's important to be sensitive as we look at this, mm-hmm. because in virtually all of these cases, the people no doubt were sexually assaulted and raped.
Yep.
It's not like there are some cases where you have false rape charges, but that's a very small minority. Mm-hmm. Most of these cases, the victims actually were sexually assaulted and raped. So why is it that they have difficulty making identification? So this gets into my research further.
Okay.
So one of the things that I recognized was that these cases are not associated with rapes that are committed by people whom the victims knew. Mm-hmm. That these cases are what are called stranger rape, meaning that the victim was attacked by someone she never knew before, mm-hmm. and her only contact with the person was during the during the period of the assault. So, as you may be able to imagine, if you had an encounter with someone who was a stranger and you'd never seen that person before, you can encounter difficulty reliably identifying that person after the fact, as opposed to someone who you already had a relationship with. So you have the fact that it's a stranger assault, coupled with the fact that sometimes, there are issues regarding like lighting at the time, how much time they actually saw the person. Sometimes offenders will say people not to look at them and things of that sort. So you have a variety of things that contribute to making the identification difficult. But the stranger rape element is a major component. In addition, you probably know that where you have a white victim who's attacked by a black or Latino assailant, you run into this other problem with cross-racial identification, where in different ethnic groups cannot reliably identify people in other ethnic groups as well as they can in their own ethnic group. So you have that additional challenge, which is a feature in many cases.
Yeah.
And additionally, you have the trauma, the strong emotions that interfere. So you have a variety of things that contribute. But let me get into the other important element here.
Okay.
The other important element here is how law enforcement conducts the investigation. What happens is if you have a woman, and obviously the victims are typically women, young woman, she reports that she was raped. She probably is examined in a medical facility where they take a rape kit, which people are familiar with, I'm certain. And then she will give a description of the attacker because she doesn't know the person. She can only say he was about this tall, he was about this complexion, maybe he had facial hair. She can describe what clothes he may or may not have worn. So she only has a description. And a lot of times with that description, they have to make a composite sketch. You've seen this depicted on films and TV where they sit with an artist or with a computer and they try to recreate what the person looked like. That process in and of itself can impair their ability to recall the actual person who attacked them. So this gets further complicated because at some point, this victim is going to get a call from the law enforcement, and they're going to ask her to come down to the precinct. We want to see if you can make some identification. So with this message, the victim believes that the police have apprehended the culprit, and she merely needs to come down and verify the person that they picked up. If the person they picked up is not guilty, it was not the culprit, and if they pick this person up and then they put him in a photo spread or a live lineup with 5 other people who have the same basic characteristics in terms of height, weight, complexion, hairstyle, and so forth, right? And she comes in, and the actual perpetrator is not there. There's a high likelihood she's going to choose someone who is there, who most resembles her recall of the offender. The victim in that situation doesn't want to come down there and look at the photo spread or lineup and say, I don't see him. Because if she says that, she believes she will be obstructing the investigation. She wants to help the investigation. So let me add this, because this is something that's not widely known. Eyewitness identifications are erroneous about 25 to 30% of the time. There has not, even when you have the same ethnic groups. We know that from studies that have been conducted in the United States, in Europe, and a variety of other countries. Eyewitness identification has a pretty substantial error rate. And so when you combine that with it being a sexual assault and the trauma associated with that, and some of the other factors I mentioned, you see how these errors are not uncommon.
No, I'm sitting here almost breathless because I've been at this for a few decades now. I thank you for at the top of this conversation, the kind of remarks you've made about the work and witness that I've tried to engage over the course of my career as a broadcaster. And this ain't my first time having a conversation in this field or in this sphere. And yet I'm learning so much in this conversation. I see so much more clearly now after years of talking about these things, why, in fact, you see so many black men and brown men who are incarcerated and, over wrongful convictions. The backstory that Professor Johnson is breaking down right now allows you to understand why the Innocence Project exists. You understand now why Brian Stevenson does the work that he does. Because if you just listen for the last 5 or 10 minutes, he's breaking down for you very clearly how we end up in this situation with black men being wrongfully convicted because they were falsely accused in the first place. You got false confessions, you got wrongful ID, and I'm getting goosebumps here listening at you tell the story of how these brothers end up being forced down the rabbit hole, as it were, and spending time in prison for years for crimes they did not commit. And then you look up every other week and there's some story about somebody in some state that's gotten out because thankfully over a period of time, either some new evidence came out or DNA evidence. We have now ways to use DNA that we didn't, 20, 30, 40, 50 years ago. But now in this conversation, I'm starting to understand the backstory for how and why this happens in the first place. I got a lot more questions. He's got a lot more answers. Our guest is Matthew Berry Johnson, professor of psychology at John Jay College, whose expertise is wrongful conviction. I'm glad about it. You're listening to Tavis Smiley. And Matthew Berry Johnson, who is a professor of psychology at John Jay College, one of the leading experts in the nation on wrongful conviction, specifically focusing on the areas of interrogation, confession that is, and wrongful conviction. He's discovered that suspects may understand their Miranda rights, but also doubt that police will actually honor those rights when they are asserted. Haven't gotten to that part of the conversation yet. I promise we're pushing our way toward that reality. I want to get him to sort of unpack what that's about in a moment. But we've been talking, in case you've just tuned in, though, about why it is that there is in this country so many false confessions. Why in this country are there so many wrongful identifications, so many false eyewitness claims? What is that about? And what role does that impact? What role does that have? What impact does it have on who we end up locking up? What's the psychology behind all of this? So I'm getting a number of messages. I want to just read one right quick, Professor Johnson, from one listener. Trauma affects memory. We were talking just about trauma a moment ago. Trauma affects memory. There are now what's called trauma-informed interviews. As a public defender, I get clients after arraignment who can't tell me the name of who repped them at arraignment. I'm not a psychologist either, Tavis, but I came to conclude that it was all about trauma. So I received that from a PD or a former PD, public defender. But here's my problem with that in these sexual assaults, and again, the name of the book that Professor Johnson has written is called Wrongful Conviction in Sexual Assault. So in these sexual assault cases, these rape cases, these women end up being traumatized. And I understand that, and again, very sensitive about that. And yet that trauma oftentimes leads to somebody else being traumatized. Why? Because they wrongfully identify in a lineup or otherwise the culprit. That culprit ends up being interrogated. You heard Professor Johnson explain earlier what that interrogation is like. And in the process, like the Central Park Five, people end up oftentimes confessing to things that they didn't do. And then you look up 20 years later, you see some story in the news about somebody that got out of prison because some new evidence came forward, some DNA evidence was found that proves that they didn't commit the crime. Some of those persons have maintained their innocence all along. But others, again, like the Central Park Five, confessed to things they didn't do, and eventually some new evidence came out and they were able to be exonerated. But you now start to understand the circuitous route and the tricky ways that lead oftentimes to black and brown men being wrongfully convicted. So that I'm thinking now, Professor Johnson, of my friend Maya Angelou, who once said to me, Tavis, processing pain without perpetuating pain is rough business. In other words, sometimes those of us who are the most traumatized end up unwittingly traumatizing other people. I digress. Your thoughts, Professor Johnson?
Yeah, I have a few thoughts about that. One of the things I want to say is that you clarified how you have devastation that the innocent person endures, followed and proceeded. That was preceded by the devastation that the rape victim endured. But I want to add this other important element, and I'm going to mention it in the context of the Central Park 5 case, because everybody knows that case. So that woman who was attacked in Central Park and almost killed, I mean, it was a horrible attack. That occurred in April of 1989. And her body was recovered, 36 hours after her body was recovered, they had these 5 confessions from these 5 juveniles. A very short period of time. So there wasn't a lot of investigation done. The investigation essentially was round up these black kids that went to park that night and get confessions from them. Once they had those confessions, everything else in the case was superfluous, meaning that once they had the confessions, they were going to get an indictment, they were going to get convictions, they were going to get lengthy sentences, and they were not going to get appellate relief. And they never got appellate relief. They only got reliefs and exoneration because the actual offender, independent on his own, came forward, admitted he committed the crime, provided evidence that only the actual perpetrator would have known, and he was the only person who was DNA connected to the evidence that was taken from the victim's body. But further, I want to illustrate something that is lost oftentimes. Mm-hmm. That offense occurred in April of 1989. In June, that offender, Matthias Reyes, raped 2 other women in Manhattan, in the same vicinity as where the Central Park jogger's body was recovered. That July, he raped 2 other women. And in August, he raped another one. So there were 5 other sexual assault victims, one of whom he killed. So it was 5 other sexual assault victims. One was murdered, that he assaulted, and this was all during the time when the Manhattan DA is preparing to try these 5 juveniles. Had they done a good job originally, those victims would have been protected. One of the women that Matthias Reyes attacked, he didn't kill her, but he stabbed her repeatedly in her eyes so she would not be able to identify him in the future. That's how vicious these attacks are. But this shows you all of the collateral damage and devastation from this crime because the police did not approach it thoroughly and properly initially. Mm. The over-reliance interrogation of the vulnerable juveniles. Yep. You know, I do talks about this, and sometimes people think that I'm not sensitive to the victimization. But wrongful conviction produces victimization. Mm-hmm. Because every innocent man that goes to prison for sexual assault, in virtually every case, that the actual perpetrator is going to continue committing offenses on and on and on. Yeah. And I can give other examples in addition to this case.
Tell me, I'm watching my timer. It's getting away from me, and I'm just trying to learn as much as I can in this hour with you. Tell me what it is you've learned as a psychologist studying these issues. What is it about these? Why is this eyewitness error rate so high? That's my question. Why is the eyewitness error rate so high? Why do we, as human beings, get it so wrong so often?
Well, you know, as I mentioned to you, I think the key thing that we have to focus on is whether or not witnesses actually are exposed to a lineup or photo spread with the actual perpetrators in there. Mm-hmm. Because if the actual perpetrator is not in there, it's difficult for people to look at it and say, no, they don't see anybody. The tendency is to look to the person who most closely resembles what they recall. Mm-hmm. You have that fact that makes it difficult.
Yep. What have you learned? What have you've talked around this? I want to come right directly to it. What have you learned about the role that race and bias play in this wrongful conviction process?
Well, racial bias plays a huge role. As I don't know if I stated explicitly, but black defendants are dramatically overrepresented among the wrongful convicted, and then particularly if there's a crime where you had a black assailant, white victim. I guess we'll talk about the Central Park jogger case more, because as I mentioned to you earlier, you had these really rushed and hasty investigations in that crime, and that was directly related, in my expert judgment, to the fact that you had a white victim and an alleged black assailant.
Yeah.
So where you have crimes where there are white victims and black assailants, there's additional burden and pressure put on law enforcement to apprehend somebody and apprehend somebody quick.
Yeah. No, I'm sorry. We've seen that, and we've seen that time and time again, not just in film, not just in movies, but in actual real world life. When we come forward, I want to get. I'm just watching my time here. I want to get to this issue that I've raised a couple times. I've got have not had a chance to ask Professor Johnson about specifically, and that is his discovery that oftentimes suspects understand their Miranda rights, but they doubt that police will actually honor those rights when they assert them. And for those, I got a really smart audience, so you all know what the Miranda rights are. You see it on TV all the time. You have the right to remain silent. You have the right to an attorney. You have the right to that's called Miranda rights. When you are read your Miranda rights, and by law, when you are arrested, you must be read, must be told, given your Miranda rights. So when people are told that, they understand it, but they doubt that the police will actually honor those Miranda rights if, in fact, they assert them. What is that about? The answer to that and more from Professor Matthew Berry Johnson when we come forward on Tavis Smiley.
Sounds different, huh? This is Tavis Smiley.
His book is called Wrongful Conviction in Sexual Assault. Wrongful Conviction in Sexual Assault. His name is Matthew Berry Johnson. He's a professor of psychology at John Jay College in New York, and I'm honored to have him on this program to talk about wrongful conviction and interrogation and confession and the high eyewitness error rate in this country and wrongful ID and all the like. It's been a fascinating hour learning a great deal more about the backstory for why and how you end up with too many black men sitting in prison for things they did not do. And then you see stories again on the regular of people getting out after serving 15, 20, 25 years for things they didn't do. Well, when you see those stories into the future, sadly, beautifully in that they get out, that's a beautiful thing, but sadly that they've served all these years rather for things they didn't do. Now you got a better understanding of the backstory of how they wound up there likely in the first place. That said, I mentioned earlier that your research has discovered also, Professor Johnson, that people understand their Miranda rights. They just don't believe the police are going to honor them. Tell me more about that part.
Yes, Tavis, I began to examine that because some of my colleagues were focusing on the fact that suspects didn't understand their Miranda rights, as though that was why these untoward outcomes emerged. And I was able to demonstrate with some of my research associates that there are people that don't understand their Miranda rights. But even among those who do understand the Miranda rights, there are questions of doubt and trust that are operating here. And what this means is that, a given suspect might understand his rights and say, well, he doesn't want to give a statement. He doesn't want to talk. He doesn't want to talk until he gets a lawyer. And the police can then say, well, you can wait for a lawyer, but you're going to be locked up until you get a lawyer, Or they can say, well, I talked to your friend, Frank, and Frank cooperated and gave me a statement. And so we're going to work with Frank and try to help Frank. So if you don't want to give a statement, we already got a statement from Frank, and it doesn't look good for you. So if you don't want to talk, that's okay, but we're just going to go with Frank's statement. So, while someone may understand their rights, the police have ways of exerting coercion and influence in this type of situation because the interrogations are not public. They're essentially they occur in privacy, and there's no record of. Most states do not require law enforcement to keep an objective record, like an audio or video record, of what's said during the interrogation. So this opens the door for these sort of secret communications.
No, when we come forward, I want to wrap our conversation with the few minutes I have left asking that very question. Whether or not, if these interrogations had to be more transparent, if police had to be more transparent with these interrogations, if a record of these interrogations, video and audio, had to be kept so we could see what actually happened in that interrogation room, would that in any way change the process? It raises the question that we've addressed 1,000 times when we start talking about police cameras. Everybody was like, if you get police cameras, it changes everything. Well, it does in some ways, and it does in other ways, particularly if they don't turn the thing on. So police cameras are not the end-all, be-all. It's not a panacea to police misbehavior. I'm wondering whether or not, if these interrogations are more transparent, it might have an impact on the outcome. That when we come forward on Tavis Smiley.
More of Tavis Smiley coming your way right now.
I've got just 3 minutes left in this conversation with Professor Matthew Berry Johnson of John Jay College, a psychology professor. Just 3 minutes left. Would making these interrogations more transparent impact this process at all, Professor Johnson?
Yes, I'm confident that it will impact the process. It will improve things. It's not going to solve everything, but it's essential. And in fact, if we don't have that information, the objective record of what was said, that is just a suppression of evidence. All of that is evidence that's important in a variety of ways. So let me mention a couple of things. I mentioned before how the interrogator can introduce false incriminating evidence. They can say, well, somebody else said you committed the crime. They can say that, we have a lab report that indicates you were at the scene. And there needs to be a record if, in fact, this false information was presented. Also, in some of these false confession cases, when the suspect confesses, they may give a somewhat detailed account of the crime. But if we don't have a record of what was exchanged, what information was exchanged prior to the confession, we might realize that everything they said about the crime, they learned from the interrogator. Mm-hmm. They didn't know it at the scene of the crime. That's how they got it, and then they just gave it back, so to speak. Yeah. So that's another reason why that record is essential. And law enforcement. There's some law enforcement officers who, if they know they're being recorded, they're not going to act out.
Right.
Now, some of them are going to act out anyway.
Sure.
But it will reduce the incidence of abuse and other types of violations if people know that they are being watched.
His book is called Wrongful Conviction in Sexual Assault. And what we have learned in this hour is that of all the crimes committed every day in this country, sexual assault is the most common offense associated with wrongful convictions. We've learned that racial bias is at the core of many of these injustices. Hence, as I said earlier, these articles that pop up from time to time about brother X, Y, or Z, who is finally being released after so many years of being falsely imprisoned. That's why, because it is the offense, sexual assault is, with the highest rate of wrongful convictions and race bias right at the center of all these injustices. We know that courtesy of the brilliant research and work done by John Jay College psychology professor Matthew Berry Johnson, who I've been honored to have had on this program for the hour. Professor Johnson, thank you for your work and your witness, and thank you for sharing with us. I deeply appreciate it, my friend.
Thank you also, Tavis. I appreciate it.
Good to have you on. Thank you for your time.
KBLA 1580 Santa Monica.